This video discusses some of the basics of breaches of contract. Almost all everyday relationships are governed by contracts, and on top of that, there are many statutes that govern these arrangements. There is also an article on the website that discusses some of the matters canvassed in this video in greater detail, which you can read at your leisure. Contracts can take a number of forms. They can either be a simple contract or a more formal contract, which is by way of a deed. Simple contracts have a number of elements that need to be complied with before a contract comes into existence, such as there needs to be an offer, acceptance, consideration, and intention to create legal relations, to name some. When a contract gets breached, the court looks at a number of considerations to try and work out what the parties meant and how to deal with a dispute. Sometimes the court implies terms into contracts to give them business efficacy, or in other instances, it looks at the arrangement and considers what a hypothetical reasonable business person would have considered the arrangement in its totality meant. Of course, contracts get breached for a variety of reasons. Some of the common reasons why a contract might be breached is because it was a verbal arrangement, which is then open to interpretation. And when memories fade, the recollections may differ. Sometimes contracts cause disputes because each side to the arrangement relies on their own forms. And then at the end of the day, there is a question about which of the standard forms governed the whole relationship. More often than not, the lack of clarity in an agreement is what causes the dispute. The aim of damages, once a contract has been breached, is generally to place the victim in the position they would have occupied if the breach did not occur. This is known as loss of bargain damages, although in some circumstances it may be necessary to seek reliance losses, such as the out-of-pocket expenses, as opposed to the bargain that was lost. There are strict time limits for bringing a claim for breach of contract. Typically, it's 6 years from the date of the breach, although where the contract is governed by legislation, it may be a shorter period. For instance, in certain building defects cases under the home building legislation, the victim would have 2 years to bring a claim in respect of a minor breach. If you have any further questions, contact litigant to discuss your breach of contract case if it involves a substantial sum of money